Why do you need to be prepared for your pretrial deposition testimony? Would you like to learn the answer to that? Come join me as I share with you this great information. Hi, I'm Jerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. First, a deposition is a question and answer session given under oath. You know, there are many people who believe that an attorney who talks to their client beforehand, before giving testimony, that somehow the attorney is telling the witness what to say, that they're putting words into the witness's mouth. And I want to share with you that nothing could be further from the truth. Now, why is that? The reality is that the preparation that goes on beforehand is basically to give you, the injured victim, an opportunity to refresh your memory about what happened. You see, your question and answer session, this deposition, this examination before trial, is going to happen many months, if not years, after your incident occurred. And chances are you probably have forgotten a lot of details. Now, the whole purpose of preparation is to get you to remember certain details. And if you don't, to then get you to refresh your memory. Plus, what we also do is we also give you samples of questions that the defense attorney is likely going to ask you. Now, why is that important? It's just to give you an understanding of what the defense attorney is going to do. And remember, this is not a test. It's not a guessing game. So, for example, if you don't remember a specific thing, your obligation is to tell the attorney, listen, I don't remember. It's been so long since this happened. Or if you're unsure of the answer, the whole purpose is not to guess. Why? Because if you guess, you could be guessing correctly, you could be guessing incorrectly. And now that's going to lock you into your testimony so that years later at trial, if you now give an answer to which you don't remember or have forgotten or are starting to guess, you may be giving an incorrect answer. In addition, one of the key things that we do is we explain how the process works. We explain the ground rules of what happens during the course of a deposition. We also explain how you have to answer questions verbally. Why? You can't just nod your head or say, yes. Why? Because there's a court reporter present and they have to take down verbal responses. They can't take a shake of the head. So what's important is that the attorney prepares you for what's going to happen during the course of that question and answer session. The attorney wants the client to testify truthfully about what happened and to give them the best opportunity to remember all the details that occurred during the course of their incident. So why do I share this with you? I share this with you because chances are you have questions and concerns about your own particular matter. And if your matter happened in New York and you have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is what I do every single day, and I welcome your call. You can reach me at 516-487-8207 or by email at lawmed10@yahoo.com. I'm Jerry Oginski here in New York. Have a wonderful day.